Hi, this is Lisa Arlen, and this is my personal message to the government. The following sections of the Child Family Community Services Act, which I state hereinafter, are the specific sections which I believe the government needs to amend, correct, or review. Section 2 of the Guiding Principles of the Child Family Community Services Act states that children are entitled to be protected from harm, abuse, neglect, or threat of harm. Where it states threat of harm, this leads to corruption, social workers having too much statutory power, and where parents experience abuse by the courts or by the Ministry for Children and Families, because anybody can state the child's at risk and perhaps they're not. And when a child is at risk in the parent's care, there may not be any specific evidence other than hearsay evidence, and this is the issue which I think the government needs to amend, and I emphasize that. Section 13, when a child needs protection in the following circumstances. If the child is likely to be harmed by the child's parent, I emphasize likely to be harmed. If the child is likely to be abused by the child's parent. If the child is likely to be physically harmed by another person and the parent is unwilling or unable to protect the child. If the child is likely to be physically harmed because of neglect by the parent. Anyone can say that the parent is neglecting the child out of spite. And I believe that if there is a report call made and there are concerns regarding the child's safety, and it ends up where the social worker determines that the child is in need of protection, that the social worker ought to make an order before court before removing the child and have specific evidence, not just a report call or hearsay evidence, that the Ministry for Children and Families intervenes but actually does an investigation before removing the child. Section 3 of the Child Community Services Act, I believe, needs to be amended. It is in the child's best interest, and it states, child is absent from home, endangers child safety. For the purpose of subsection 1E, a child is emotionally harmed if the child demonstrates severe anxiety, depression, withdrawal, or self-destructive or aggressive behavior. If this is the situation, then I believe that the ministry needs to refer the child to a psychologist who is certified to determine this. Duty to report. This also needs to be amended. Section 14.1. A person who has reason to believe that a child needs protection. Again, I would say that the social worker must have specific evidence, not just hearsay evidence, and that there should be a full and complete review prior to removing the child, and that the Ministry for Children and Families, the social worker who is investigating the situation, that needs to get a court order. I emphasize that. And Section 4. A person who knowingly reports to a director, or a person who is designated by a director, gives false information that the child needs protection, commits an offense. And then it states, Section 5, no action for damages may be brought unless, like the social worker, knowingly reported false information. And this is really difficult to prove. That does not really offer much protection for parents. And I think this needs to be amended. I think that it is appalling that the Child Family Community Services Act has ignored parents' rights. And I think that it's about time that the government, instead of turning a blind eye to this issue, actually deals with it, and parents' rights are protected. Thank you very much.